Good evening, everyone. A legal luminary, Professor Türk wears multiple hats as Vice Dean at the Dixon Poon School of Law, KCL. His diverse academic journey spans Germany, Belgium, and the UK. With expertise in EU law, comparative constitutional law, and US legal principles, the talk promises to be a stimulating study of constitutional dynamics. In this lecture, Professor Alexander Türk will discuss the seismic shift in the recent jurisprudence by the US Supreme Court in its interpretation of the rights that US citizens enjoy against the intervention of states in the USA. The Supreme Court has historically imposed significant constraints on states through an expansive interpretation of liberty within the 14th Amendment of the US Constitution. The court has shaped politically sensitive realms: abortion, marriage, same-sex relations, and diversity in university admissions. And by denying the existence of a constitutionally protected right to abortion in its recent ruling in Dobbs, the current Supreme Court has embarked on a journey that has potentially far-reaching consequences for a large number of liberty rights that many US citizens have come to enjoy. This talk will explore whether the minority in Dobbs was right when it stated that power, not reason, is the new currency of this court's decision-making. So please join me in welcoming Professor Türk this evening.
Hello, everybody. Thank you very much for coming and joining this talk here in the hall, but also online. It's a great pleasure to be here. Also, since we share a common history, 1829 at King's. I'm from the law school, and the law school was also founded in 1829. We picked up our first lectures in 1831. King's was one of the first law schools to actually offer lessons in the English common law, whereas if you look at other universities and other law schools, it was an English common law that was actually taught at that time, and we still continue that tradition until today. Also, we have actually branched out into international law, so I'm an example of that, of a very sort of diverse, internationally diverse faculty from very different countries around the world. Also, our student intake is very diverse, and we teach any number of subjects of international law, European law, but we also enjoy teaching comparative constitutional law. In my job, actually, I have also the privilege of going around the world. I've just basically come back from India, and in India, sort of, you also get to know the Supreme Court. So we had a visit to the Supreme Court, and in the Supreme Court, we learned at that time that the Indian Supreme Court had just instituted a right to an abortion for unmarried women. There already was a right to an abortion under the Constitution, the Indian Constitution, for married women, but that has now been extended to unmarried women. And so you get to basically see how around the world this basically is pursued and how liberty is defined. And this is basically what the talk is all about. I'm very grateful that you have chosen this talk over another episode of One Day, but basically you might actually come to regret this. But let's see why I think this is a particular interesting moment in time where the Supreme Court seemed to have pivoted away from, as Ben said, and introduced a rather liberal interpretation of freedom to a far more restrictive one. And so I'm here not to judge the politics. I'm here as a lawyer. And so what you get from me is not a political assessment. I'm not able to deliver that. Everyone might be able to do that, but in my day job, I'm basically looking at the law and the contribution that the law can make and how it is interpreted. So if we look at the text, and lawyers are particularly obsessive about text, you will see in the 14th Amendment that it raises quite a number of interesting questions. When you actually say, were the drafters clear of what they wanted to do? The answer is probably in 1868, when the 14th Amendment was introduced, they were not. In other words, this text is a compromise between many various different versions. So ultimately what they settled on after the Civil War in the United States, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. What you find then, there are actually not one clauses, you actually find three different clauses. you find what we call privileges or immunities. In other words, citizens are entitled to privileges or immunities, and what are those? Then actually you find the substantive due process clause, which is around life, liberty, or property. And then you find the equal protection clause here as well, the equal protection of the laws. What I'm going to look at in particular is not privileges or immunities and not the equal protection clause, but how does one interpret liberty in this particular context. Now, the first thing you notice is that the 14th Amendment only applies to states. It doesn't apply to the federal government. This is important because for a very long time the US Constitution was set up to restrain the federal government. However, people discovered with the Civil War that the states can equally be problematic on actually encroaching on rights of individuals. So slavery was abolished. That is a different amendment. And then basically the 14th Amendment was to provide a framework within which states were meant to operate, things they could not do without sort of infringing the US Constitution. Now, if you go back basically again to the text, it seems to be mainly referring to a procedural requirement. So if you carefully read, nor shall any state deprive any person of liberty without due process of law, you might actually think, I can throw you into prison as long as I hear you, right? Have you done it? Yes, no, okay, maybe I'm not convinced you did it or you didn't do it. I throw you into prison anyway. I have heard you. You have no rights. You have no substantive rights. The only right you have is that you're not deprived of the due process of law, which is many seen as a procedural requirement only. Incidentally, one of the 9 justices in the Supreme Court today, Justice Thomas, would consider that there is no substantive due process clause. He says this clause is entirely procedural. You have hearing rights, yes. If we encroach upon your liberty, you need to be heard first, but you have no substantive rights. So the question is, how has actually the Supreme Court ended up with injecting substantive rights into a clause which seemed to be entirely designed to be merely procedural? What you will find is that initially it wasn't actually privacy or abortion or any of these things that attracted the attention of the Supreme Court. It was predominantly economic liberties, your right to contract. In other words, what underpins an economic society that is basically based on capitalism. Right? So in a sense, what is the basic foundation of that? Contract law. You have the right to contract. So that was basically the economic liberties came first, then came privacy. Privacy is only a development of the 20th century and sort of the middle of the 20th century. In essence, economic liberties are a much older strand of the substantive due process clause. Now the question is, how do I build a substantive due process clause? If I believe it's not just about procedure, if there is substance, what is the substance of my liberty right? There are various ways in which I can approach this. I can look at the history. What in 1868 did people believe to be part of the mix of liberty? And that's an interesting conversation because the drafters of 1866 were all men. Women actually at that point were not allowed to hold property, or at least could not dispose of property, or there were severe limitations on it. There were a number of things. For example, a number of states did not recognize a right to abortion. Quite the opposite. The vast majority of states would actually criminalize abortion. The vast majority of states would also not allow you to marry across racial divides. A black woman could not marry a white man. 30 out of 48 states would not allow that. So in a sense, you will see by the end of the 19th century, if we take a historical approach to what was liberty in 1868, you will find a rather narrow view. But then we can say we can't freeze the constitutional interpretation in a particular time. Things evolve. The constitutional consensus evolves. People have different ideas. Technology arises. There is the car, there is the internet, there is the railway. Not necessarily all in the same order, but you'll see that what happened in 1868 and what people worried about, what even encroaching on their liberty, is not what we worry about. We worry about AI. Now, there was no such thing as AI in 1868. There was no such thing as a Tesla car in 18. There was no such thing as Twitter, and there was no such thing as YouTube. Right? So online and computer didn't exist. So what's the answer to the law of how we tackle liberties that we worry about? So shall we judge a substantive due process clause and construct it through an evolving consensus that evolves socially in society? Or could we just say, well, all of this is just subjective judicial lawmaking. These judges make it up as they go along. So where's the limit? Lawyers need limits. They draw lines. Where do we draw the line? Which rights are in, which rights are out? Now, the reason I mention this is because all of these you will find in the jurisprudence of the Supreme Court, and you find them at different times with different emphasis. Let's start with having a look at economic liberties. Now, some of these rights come up, and then they basically fade away. And this is true for contract rights. So, in a very famous case called Allgaier, the Supreme Court actually had to decide what liberty means, and the Supreme Court said it has a substantive content, right? So the first thing they agreed on is not just procedural, it is substantive. It does not just mean liberty free from physical restraints. That was the common law approach. It also meant to enjoy all of your faculties. That means your mental and physical faculties. So actually do what you want to do in your life, and that means to enter into a contract. Obviously, this was basically taken to its extreme in a case that's now been overruled, but was actually very famous at the time, called Lochner. Here, the Supreme Court strikes down a New York labor law of what we could call social legislation, that nobody in a bakery as an employee shall work longer than 10 hours a day and not longer than 60 hours in a week. You might say this would be a kind of social protection law of bakers. That sounds actually, in our eyes, quite sensible. The Supreme Court disagreed because the Supreme Court said that's an unreasonable interference with the right of contract. If an employer says, I hire you for 80 hours and 12 hours a week, or 12 hours a day and 80 hours a week, why should that not be the case? The Supreme Court said bakers are not a particularly dangerous trade, although if you know that you have to get up at 3 o'clock in the morning and you do this over a decade, then you know this is not particularly healthy. But the Supreme Court said there's nothing more unhealthy about bakers than there would be about working in a coal mine and so on. So actually was not convinced there were legitimate means to achieve the end. Then the financial crisis hit in the United States. Roosevelt comes to power on a ticket and a vast majority supporting him as president to say you need to fix the economy, you need to fix the financial system. Right? So when you think about what worse times were there in the United States, we think the financial crisis of 2008 was bad. Think back to the 1930s, that was very, very dark times for most American citizens. Quite a large number of them lost their jobs, lost their homes. And so Roosevelt came in and says, we want to protect people. So social legislation became high up on the agenda. And the Supreme Court did not change tack. The Supreme Court continued and actually said, we insist on a contract being a contract, and we will strike down any of this basically stuff that Roosevelt brings in about the New Deal because we don't believe in it. Then Roosevelt says, okay, if that's what you do, then we're starting to appoint more justices on the Supreme Court. So instead of 9, we might have 15, right? And we'll change the majority, the packing of the court. And then the Supreme Court changes tack because quite a lot of justices on the bench felt uneasy about going against a democratically elected government of what you actually saw is a very limited clause, shall not be deprived of due process when you encroach on liberty. In other words, quite a lot of justices were arguing, look, we have a democratically elected government and a democratically elected president. Can we really overturn, in the middle of a financial crisis, economic crisis, the will of the majority of the people? And so the Supreme Court retracts. You find Nebbia, West Coast Hotel, suddenly the Supreme Court starts upholding the New Deal legislation, right? The switch in time that saved the 9. Actually, most of these decisions were 5-4. One of the justices moves from the side of upholding contracts to the other side, and actually suddenly Roosevelt gets his majority in the Supreme Court. Decisions now go in favor 5-4 in favor of basically the US government. Now the US Supreme Court does not stop here. It then actually says, well, for economic liberties, we now do a full sense retreat. And Lee Optical is pretty much the highlight of what is now applied to contract law. The contract law basis is now assessed against no longer strict scrutiny, but actually rational basis. What does rational basis mean? It means a law can be stupid. It doesn't have to be convincing for anybody as long as it is rationally related to a legitimate end. In this case, Williamson versus Lee Optical, you have a law where ophthalmologists and optometrists need to write a prescription so an optician can fit lenses into glasses. What happens if I want new glasses with the same lenses? You need an ophthalmologist or an optometrist prescription. What happens if my lenses break and I want the exact same lenses? You need an ophthalmologist or an optometrist prescription. You can say that makes optometrists and ophthalmologists very rich. It doesn't do much for the citizens. The Supreme Court says, we don't care. If the legislator decides that is what I want to do, that is what I want to do. So here we see a judicial retreat to the very low level of rational basis. Why is this important, you might wonder, when we then come to abortion? Well, you will see why. Because the current test of the Supreme Court in relation to abortion is exactly that, rational basis. And that has consequences to the assessment of all kinds of legislation. So we will be back to this. So now basically the question is, can we apply these kind of ideas that there is substance in the due process clause to areas other than economic liberties? Can we actually include the right to privacy in this? Right? So if you think about privacy, you can define it as aspects of individual decision-making that are so personal that they affect your own autonomy and should keep the state out of it. Family formation, marriage, child rearing, abortion, contraception, is that all part of it? Is that part of the concept of privacy? And how does one define liberty? And now here the Supreme Court veers into different directions. The Supreme Court now basically decides that should that be dignity and autonomy? And for a very long time, from about basically the middle of the 20th century, dignity and autonomy is the trend that you will see up to Roe v. Wade, where the Supreme Court recognizes the right of an abortion, which is based on dignity and autonomy, on the basis of this is an individual decision so personally to me that the state cannot intervene in this decision-making, right? So the right to use contraceptives, the right to have an abortion, that's the trend you will see. Recently now, with the new Supreme Court and more conservative justices, this has been now thrown overboard in favor of a new test. And the new test is, it will only be a liberty right if it is deeply rooted in this nation's tradition and implicit in an ordered scheme of liberty. Right? So we will see why the Supreme Court moves away from dignity and autonomy and moves towards a much narrower definition of liberty. And the best case to demonstrate that is really Casey. Now you will say, where's Roe v. Wade? I was expecting Roe v. Wade, and you might want to ask for your money back. Now, in this particular instance, Roe v. Wade in certain parts was upheld in Casey, but it was treated like a Grade 1 listed building. You leave the facade and you rip everything out that is in there, right? So Casey says, we are upholding the right to an abortion in Roe v. Wade, but we are putting it on a completely different footing. So what actually applied in the United States up until Dobbs, the recent case that changed the right to an abortion, is actually Casey, a case you might not have necessarily heard about. Interestingly is the reasoning now in Casey. We are actually particularly interested in how does one define liberty. And here, Justice O'Connor, who basically wrote the majority opinion, says there are certain decisions which are already protected by the Constitution, and they revolve around marriage, procreation, contraception, family relationships, child rearing, and education. Goes back to a very famous case, Meyer versus Nebraska, where somebody in Nebraska wants to teach German. And the state of Nebraska says, you cannot teach German. You might wonder why. Well, that was just after the First World War, so the Americans were participating in the First World War on the Allied side. So you might feel Nebraska didn't want people to speak German. Meyer takes the case to the Supreme Court. The Supreme Court says there are personal decisions that parents take when they want their children educated, or the children themselves, that are so personal that the state cannot intervene. And learning German is one of them, right? So it's for the parents to decide what the children learn, and the language is not offensive, and therefore the Supreme Court struck down the Nebraskan law that says you can't teach your kids German. Similarly, the Supreme Court strikes down that you cannot use contraceptives between married couples in your own home, Griswold, and so on. So basically, O'Connor says, let's go back to the established jurisprudence where the Supreme Court has established a right of privacy, a zone that protects individual decision-making. So this is a zone which is so fundamental to your development that it needs to be protected from state intervention. So this is an area of family life where the state is not allowed to enter. And these are, and this is a very sort of famous part of the decision, is actually the most intimate and personal choices a person can make in a lifetime, choices central to personal dignity and autonomy. And here you have it, right? Dignity and autonomy as the light theme of the Supreme Court, here brought out by Justice O'Connor. Now, interestingly, she goes one step further and says liberty goes much beyond that. It is actually the right to define one's own concept of existence, of meaning of the universe, and of the mystery of human lives. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. In other words, there is a zone where you as an individual can develop your own beliefs, you can make your decision-making. Why is abortion here particularly important? Because previously Roe v. Wade located abortion and the right to privacy. Now O'Connor says, well, let's move away from that. She doesn't expressly say that, but when you actually look at the definition of liberty, she moves away from the right of privacy, and she firmly grounds it in her understanding, and by the way, the majority understanding of the court in Casey on the definition of liberty as a personal decision. Why is abortion in there? Because of the consequences for women, O'Connor says. These are deeply personal consequences. Whichever decision you will make, it will be difficult. And that difficulty shall only be decided by one person, and that is the pregnant mother, and nobody else can make that decision for her, because the physiological consequences, the mental consequences, the financial consequences are all there and they're real. Therefore, this is a decision that only the woman can make. And that basically introduced and established the basis for the right of an abortion after Roe v. Wade on a firm basis. Now, what other rights are recognized on that basis? Obviously, the right to marriage. And you might say, well, that seems to be obvious. Well, it wasn't obvious to the United States Supreme Court. Take a decision of the end of the 1880s, 1888, I think, in a case called Page, where the Supreme Court rules if a state of the United States decides that a black woman cannot marry a white man, that is unproblematic under the 14th Amendment. There is no constitutional prohibition for a state to do that. So a very long time, many states in the United States has what we call anti-miscegenation laws, that actually you cannot marry across racial line if that is what the state decides. That is overruled in 1967 in a case called Loving. Mildred Loving, an African-American woman, marries Richard Loving. You might say, somebody invented these names for the particular case. The answer is no, they didn't. These were real people. Mildred and Richard were as real as anybody else in this room. And they wanted to marry, and they did marry in Washington, D.C. They go back to Virginia, and Virginia says, well, you have just violated a criminal statute of Virginia. A black person cannot marry a white person. This goes to criminal trial. They get convicted in a criminal court, and the judge says, look, I do you a favor. I don't throw you into jail. If you leave the state for 25 years and do not come back, you can leave. Right? So in other words, the state says, well, the judge says, leave the state, don't come back, and everything is fine. You can freely walk out of this courtroom. The Lovings take their case to the Supreme Court. The Supreme Court overturns Page and actually said, there is a substantive liberty right that you have, that you can marry whoever you want. If that happens to be of a different race, so be it. Obviously, this is also a violation of the Equal Protection Clause, because race cannot be a classification, says the Supreme Court. Same is true for Lawrence versus Texas, overruling another case previously in Bowers, where actually sodomy was upheld by the Supreme Court, so a state introduced a prohibition on sodomy. The Supreme Court upholds this. Lawrence versus Texas, on the basis of dignity and autonomy, overrules the earlier decision in Bowers and actually says, with whom you have sex in basically a consensual way, whether same sex or different sex doesn't really matter, with whom you have intimate relationships is only your business and none of the business of the state, and it certainly can't be criminalized. The next step, of course, is then same-sex marriage. Obergefell, the Supreme Court says, not only are you free from interference from the state, but you also should have the same right to commit to another person in marriage. If they are from the same sex, that is okay. So you will see a host of cases that actually are all built on the same theme, dignity and autonomy of the person, which underpins all of those decisions of the Supreme Court. There is one odd one out here, the right to die. You will see Chief Justice basically Rehnquist in this particular case more on the conservative side, who was in any of the other cases, or most of the other cases on the minority, suddenly writes the majority opinion and says, what does liberty mean to a conservative justice? And he says, none of that dignity and autonomy stuff. The right is only accepted as a liberty right if it is grounded in the tradition of the United States, deeply rooted in the tradition of this country and part of a scheme of ordered liberty. And he comes to the decision in a 5-4 decision that the right to die, Washington v. Glucksberg, is not part of that. In other words, you cannot, there is no fundamental right to assistance in suicide. Right? So if a state wants to criminalize assisted suicide, the state is entitled to do that. What you have a right to is that you can decide to have treatment withdrawn. So at any point in time, you as a patient can say, no more. I want the treatment withdrawn. I want to die in dignity. Rehnquist says, that's okay. What is not rooted in the tradition of this country, that is the United States, is a right of assistance in suicide. That is not covered by the Constitution. Now, let's come on to Dobbs now. So Dobbs is now the case where the whole thing changes quite dramatically. And the question is, in and of itself, Dobbs abolishes the right to an abortion, to be clear about that. But the question is, what are the knock-on effects? And when I said there are two strands in the jurisprudence of the Supreme Court, one is dignity and autonomy, and the other one is deeply rooted in the nation's tradition and part of ordered liberty. Dobbs, like basically Washington v. Glucksberg and Rehnquist, is actually based on that other strand. That other strand that includes a right can only be accepted under the 14th Amendment if it's deeply rooted in this nation's tradition. So actually here we have a law in Mississippi which says you can only have an abortion up to 15 weeks unless basically the life or health of the mother is affected. But any abortion beyond 15 weeks are not allowed. So Justice Alito writes the opinion for the majority, and he basically has a go at Roe v. Wade and Casey. And he actually says, Roe v. Wade and Casey are not grounded in the text. He says, we are lawyers, we're not freewheeling traditional lawmakers. We have a mandate, and the mandate is that of the Constitution, and you guys in Roe v. Wade and Casey have overstepped the mark. So, the question he therefore asks is, this dignity and autonomy is just an excuse to make the law up as you go along, and therefore we need to go back to basics. And basics is deeply rooted in this nation's tradition. Is abortion deeply rooted in this nation's tradition? And he says, there is no right to an abortion in the history. And he goes back to England, actually, back to quickening, basically, in the Middle Ages, and he makes his way all the way through the common law, and then ends up in 1868 and says in 1868 how many states basically had a abortion criminalized. As it turned out, the vast majority of states in 1868 had abortion criminalized. Footnote, as I said, 1868, the 14th Amendment at the time was made all by men. There was not a single woman basically involved and in the room to make that decision. So you could say, well, how legitimate is basically an understanding of 1868 if it's deeply rooted in the nation's traditions? Can we simply blend out the other 50% as if they were not there and in the room, right? So, but he says, let's look back at history, 1868. Most states had criminalized abortion, and only with Roe v. Wade in the middle of the 20th century was there a right to an abortion when none actually existed in most of the states of the United States. So his is a historical approach. But you say, well, how is this right grounded? And he said it wasn't. Secondly, he says autonomy is too broad a concept because this is just an excuse to make laws when judges shouldn't make laws. And he also says abortion is different from other privacy rights. You will see why that matters later on. Is different from other liberty rights because it affects unborn life. It is one thing to say, I can do in the bedroom between two consensual adults what I please to do. It's another thing to actually destroy unborn life, as basically he would call it. Right? So, in a sense, there is something different, qualitatively different about abortion that does not exist to other rights. Therefore, he says, we are going to give back as the Supreme Court the right to the rightful and legitimate decision maker, the democratically elected legislator in the states. It's not for us as the third branch, the judiciary, to make these decisions, and it has been wrong for the Supreme Court to do that. The 14th Amendment is no basis to make those judicial decisions. The states. However this goes, he says, this is not for us to decide. You can prescribe abortion, allow it. Either way, it's your decision. And so the decision ends by basically saying, we give this right back to you. Why is this important? Because a woman who now has an argument to say, do I have any kind of liberty interest in abortion? The answer is yes, but this is subject to rational basis. Remember the ophthalmologists and the optometrists. In other words, the Supreme Court says, yes, you have a liberty interest under the 14th Amendment, but the state can override it through laws that might well be considered as stupid as long as they're not irrational. Right? So this is basically now the position in law where the Supreme Court ended up. Now, if you look at other justices, Justice Thomas would go even one step further. He concurs with Justice Alito, and he actually says, well, there is no such thing as substantive due process. He says, while we're at it, we might as well actually make it clear that this has an impact on other cases. So while we're at it, we might want to point out that Griswold, Lawrence, and Obergefell need to be reconsidered. Remember, Obergefell was same-sex marriage. Lawrence was actually sex between gay people. Griswold was the right to contraceptives in your own home between married couples. All of that, Justice Thomas says, has got to go, or at least needs to have another look at. Now, Justice Kavanaugh, appointed by Donald Trump, basically to the Supreme Court, actually says, well, let's not look at Griswold, Eisenstadt, Loving, and Obergefell. Let's keep them where they are. Justice Alito says, my decision, or basically my opinion, should not be read in any way to impact on all these other cases. So Kavanaugh says, Justice Thomas is out on a limb. While we concur there is no right in abortion, but let's not be rash when the case comes before us, we're going to look at it. Chief Justice Roberts is sort of now in the middle of all of this. He's the Chief Justice. He has to bring the various tribes together and actually say, can we find some middle ground? And the only problem with the middle ground is that the left and the right basically has a go at him and says, what you are proposing makes absolutely zero sense. Either there is a right to an abortion or there isn't. Your approach, which I'm not going to explain now, nobody actually accepted, so we don't really need to go through it. So here is now the dissent, as Ben basically in the introduction said. Can we now actually say here, if we go with the dissent, is this right that this is a power trip of the majority? So the question will well be, what actually the majority disagrees with is the deeply rooted in the nation's tradition approach, the historical approach, because they said that does not take into account any evolution, either in the social consciousness of the nation, nor any technological advance. We're actually freezing rights in time, and that must be wrong. There are also far-reaching consequences when actually Justice Alito says, don't worry about Obergefell or Lawrence or any of these cases. The dissent says, yeah, actually you should worry. When they have to say this, that is precisely when you need to worry, because these decisions will be next. Let's not kid ourselves. If we approach this by deeply rooted in the nation's tradition, then same-sex marriage will go, because in 1868 there was no deeply rooted right of a same-sex marriage. Lawrence probably will have to go. Gay sex was actually criminalized in most states. And actually even loving might be problematic because most states had anti-miscegenation laws. You could not marry across racial lines. So if 1868 is your benchmark, even loving might now be in doubt, at least from a substantive due process perspective, maybe not from an equal protection perspective. But actually the historical methodology is deeply flawed, and also it ignores our previous case law, which we should only overrule when there actually is a really good reason, and the majority says there isn't. So what's the impact now? So the impact, obviously, on abortion is not yet settled, because while there is no right to an abortion under the 14th Amendment, what happens if a woman travels from state A to state B? Can state A says, you cannot leave the state. If you do, we will basically restrain you. The argument is probably under the Constitution there is a right to travel. That's where privileges or immunities will come in, and actually allows you to travel. And if the reason is to have an abortion, then actually that will be probably protected. But the question would be, what right of judicial review do we apply? If you apply a rational basis for that, then the state can say you can't travel outside to have an abortion. Would that be basically questionable? Of course, but all we need is a rational basis. If, on the other hand, what the Supreme Court has decided so far, you need a compelling interest, then the state would lack a compelling interest, right? So, in that sense, there are some issues that need to be sorted out. What is the impact on Griswold, the right to use contraceptives? Well, in 1868, it might well be said that if there were not yet contraceptives invented, and probably there weren't, then this poses a problem to the Supreme Court, is how do I assess something that wasn't there? Maybe there were condoms, but maybe there was nothing else in terms of contraceptives. So condoms are okay, everything else isn't, is probably not the answer you're looking for. Lawrence's right to sexual intimacy will probably also be looked at. Definitely in 1868, there were a number of laws that criminalized that kind of conduct. So will Lawrence be overruled? Likely. Will Obergefell be overruled? Very likely. So Obergefell is the most likely candidate for overruling. The question, are there other cases? I mentioned Loving, for example. But would Mayer versus Nebraska be have another look at? What about language regimes in 1868? If German wasn't basically a recognized language, then learning languages like German or French or Italian or whatever you have, or say Mandarin, in 1868, was that deeply rooted in the nation's tradition that one could learn any of these languages? And the answer is, I don't know. Maybe it wasn't, maybe it was. Should we actually overrule Mayer versus Nebraska? Or is Justice Thomas right? Shall we just do away with all of that substantive due process stuff where we actually say there is no substantive due process clause? That would have the advantage of clarity, right? Because you say, well, privileges or immunities is your answer. So the question, therefore, is what is the limit of liberty after Dobbs? And the answer is it must be deeply rooted in the nation's tradition. And so which of those rights are in might be easily ascertainable if you are a historian. Of course, for all of those justices who didn't study history, that will be a problem. But for those who did, they can find this out. But it will be a very narrow range. Liberty will mean no longer to make your own personal decisions. It will only mean what some other guys 100 years ago or more than 100 years ago actually decided is a right of liberty that will be recognized. And that's basically the decision the United States Supreme Court will have to apply to a whole host of cases. So that definitely means that liberty will actually be shrinking much more quickly than you think. And that's a decision for the Supreme Court to convince us that this is the right direction. Actually, not me personally, but actually the citizens of the United States need to be convinced that that is a direction they want to travel in. But that is the direction of travel. So more questions I'm giving you here than answers, but that's usually what lawyers do. You consult a lawyer, and you ask 3 lawyers, you get 4 opinions, and that's exactly what I'm giving you today. Thank you very much.
Thank you very much, Professor Türk. That was enlightening. Now, I am blessed to be the one with the microphone, so I'm going to start you off selfishly with a few of my own questions. So you spoke there about there sort of being 2 distinctive branches for the criteria as to what constitutes liberty. You said dignity and autonomy was one, and then the other version was whether it was deeply rooted in the tradition of 1848. And my question to you is a slightly tough one, because to my mind there seem to be a host of problems. Like you said, who were the decision makers in 1868? You know, new technologies like the internet. And even if you take the argument that you can apply existing principles from older technologies to newer technologies, why are those principles inherently right? What was so halcyon, so Arcadian about 1848? And why are we picking that as the golden age to judge laws against? So can you think of a good reason as to why we should take that second approach of whether something's traditionally rooted in the history?
As a lawyer, I can think of many good reasons. If I just basically go back to Justice Alito says we are lawyers. We're not policymakers. We do not have a democratic mandate. We're not engineers. We're not doctors. We don't understand any of these things. And all of these things are true. I'm not an engineer. I'm not a doctor. I'm a lawyer. And as a lawyer, we actually need to use the tools of interpretation. If we are interpreting the Constitution, then we need to look at the text. So I'm just putting myself into the shoes of Justice Alito. So I'm channeling my inner Justice Alito here. So not necessarily that I'm supporting this opinion, but just to give you a reason, so how Justice Alito would reason. And he says there is no good benchmark that we can apply that comes from autonomy and dignity, because it's not part of the 14th Amendment. The 14th Amendment does not say, and hereby dignity and autonomy is protected. It protects due process of liberty. So we will need to see, if it's not expressly mentioned in the text, how do we root it in basically the understanding that the drafters of the 14th Amendment of 1868, what was their understanding? So we will look at the historical development. And if by 1868, or maybe shortly thereafter, it wasn't deeply rooted in the nation's tradition, then we cannot take it as their understanding of liberty. And it is their understanding of liberty that would matter, right? So that would basically mean a number of cases might well survive. We might basically have generating a right of privacy. Justice Alito is very clear that the right to an abortion or basically that there is no right to an abortion and Dobbs does not affect of all the other cases. Of course, this is basically what justices normally do. You wait for the next case when you have to decide the issue. You don't decide something that you don't have to decide. But we'll say, well, then we will apply the test. Is it deeply rooted in the nation's tradition? And that is the mandate that we have. On that sound, we are basically safe. We are retreating to a ground from which we can claim that we're not interfering with the democratic mandate of the elected legislator. So that would probably be the argument.
Thank you very much. And if I can sneak in for one more question. Throughout your talk, you sort of charted the history of the Supreme Court a little bit, their decisions. And it seemed that there was quite a lot of them changing their mind, effectively. I mean, Dobbs itself is, overturning Roe v. Wade. And my question is, if the law is going to be sort of that protean, that wavering, is there any rule of law at all? Does it sort of undermine the confidence in the law?
That was an interesting question that Justice Alito raised in the majority. He spends quite a lot of time to say, even if Roe v. Wade is wrong, shall we overrule it? Stare decisis, the belief in precedent. Precedent is actually that you should not overrule previous decisions of the Supreme Court unless they're egregiously wrong, and there has been some change in our understanding of the Constitution. He actually comes to the conclusion Roe v. Wade and Casey were egregiously wrong decisions. They weren't just wrong, they were fundamentally flawed as a matter of tradition, and basically they definitely did not consider that. The problem, of course, that one runs into that, it might well be a trigger of I'm overruling now everything that I don't like, right? So what Justice Alito had to take great care to say, well, how do we anchor decisions? And of course, you're absolutely right. The Supreme Court has changed their mind several times. Take basically Plessy. Plessy actually says separate but equal. So if a state introduces a law where black travelers travel in the black coach and white travelers travel in the white coach, then that law was upheld because it's separate but equal. It's not a violation of the Equal Protection Clause because both are treated equally. There will be a coach for African Americans, there will be a coach for white people, and they all have their own coach. And in Plessy, the justices actually said, well, this is a social problem. We as judges, we can't fix that. Then basically a number of cases come out where it turns out separate does not mean equal because the schools and the universities for the black kids actually do not exist. In one case, the state legislator says, well, we don't have a university for black kids. Never mind, we're going to send you to Canada. And the Supreme Court says, no, you can't do that. Oh, yes, we do have basically a university for blacks, but they're basically inferior. Never mind, we basically give you a voucher. The Supreme Court says, no, you can't do that either. Or actually a state says, yes, we accept there are black students and they don't have actually good universities. We'll send you to the ones with the white kids. And then suddenly it turns out, but you can't sit in the same classroom. You could not sit in the same lecture hall if you were a black student. Yes, you can go to the same university, but you can't sit in the same hall. You would have to sit in another hall. So I would have to give this talk to two people at a different time. You cannot even sit in the same cafeteria. You cannot sit in the same library. You cannot basically sit in the same, you cannot use the same swimming pool. Separate but equal, therefore, meant basically just that, an exclusion. So the Supreme Court then actually comes to the conclusion that all of this is wrong, overturns themselves versus Brown versus Board of Education, and says separate but equal does not work. What does that mean for the rule of law? Well, lawyers change their mind. And whenever you basically consult them and you go to court, you will actually say, there is no justice that is constant. What you get in a court is a judgment. As best reason as the judges can make it, but there is not a mathematical operation that if I put in £2, I get exactly the same results over and over and over again. It's a reasoning process. That's why any kind of reasoning of justices has to basically convince people to take them with you. If people are not convinced by what you are deciding, it doesn't mean a popularity context, but if my reasoning does not take people with me, I will have to overrule myself. So Plessy got overruled, Page got overruled, Bowers got overruled, and yes, Roe v. Wade got overruled. So the answer is there is no such thing as a constant decision.
Thank you very much. I'm going to open up to the audience now. Jet, no questions?
Yes?
And I guess with the shift in the Supreme Court that you talked about, things being deeply rooted in the American tradition, has the right to have a gun in the US become more entrenched by these changes?
Absolutely. So in other words, here is a right where the Supreme Court said that right exists. It's expressly mentioned in the Second Amendment. So therefore, you can invoke it against the federal government. And it also has been considered to be incorporated into the 14th Amendment. So I can invoke it against state legislators. So if a state legislator says you cannot carry guns, or in the state of New York, in the Bryn case that the Supreme Court decided a few years back, that where New York State said you need a license for a gun, the Supreme Court has overturned this and said that's incompatible with basically the right to bear arms. The difference to our discussion is that the right to bear arms is expressly provided in the Constitution, the Supreme Court says. Of course, you can query that. If you read the Second Amendment carefully, you will see as part of a well-regulated militia. So until very recently, the Supreme Court said, if this is not a firearm that you're wearing as part of your militia, then it's not recognized. Justice Scalia overturns this and actually now argues, forget about the militia bit, what you have is a right to bear arms. And now the Supreme Court has to deal with any number of very difficult questions. How big is a gun for it to be outlawed? Can I actually outlaw an AK-47? How about a rocket grenade launcher? Is that still an arm that I can carry? Can I exclude schools in this? As a school, can I say there are no weapons within 100 meters of my school? All of this the Supreme Court would probably recognize, but there's a current case going where you actually say, well, what's the size of the gun that actually makes it unlawful and which ones is still traditionally recognized? But it goes down again, you can only restrict that right if the restriction was traditionally accepted. So forget about the westerns that you have watched in Dodge City where you have to hand over your weapon at the entry to Dodge City. It will be something like no schools. If you basically have background checks for certain people, they are accepted, and basically a certain caliber of weapons cannot be allowed. But the current question is how big is big? Because in basically in the 18th century, that's where we have to go back, when the Constitution was adopted, end of the 18th century, you will find that there were many arms around then, and what arms you can buy now is fundamentally different. They just didn't exist at the time. But the answer is yes, deeply rooted is the answer to any of those questions.
Very much. Any other questions? Yeah.
Are there cases currently working in the system that will intend to get the Supreme Court and challenge Optical and Lawrence?
Not that I know of, but they are bound to happen. They are basically bound to make their way at some point. We now know basically the Supreme Court has just dealt with the insurrectionist clause of the Section 3, which I haven't discussed, the 14th Amendment, and has said an individual state cannot decide presidential elections or federal elections, because that's at least what the majority said can only be decided by federal Congress. So then the next case is the immunity case of Donald Trump. When does a president have immunity? But these cases of Obergefell, people might have just forgotten about them, but they will be coming up and they will be challenged. Probably it depends on maybe how the election goes or how other cases are going to make their way, because in some cases you need lawyers who need to support that. DOPS was supported by, I think, over 20 states who wanted similar laws as Mississippi, so there was quite a big drive behind the states. There might not be a similarly big drive to overturn Obergefell, but there will be a case that will make its way to the Supreme Court. There are any number of conservative action groups that are just basically waiting for this to go up, and they will support it. The answer is, I don't know yet of any case, but they will come.
Anyone else? Can I slide in then with another question? You mentioned in Lochner v. New York, right? That was the case about working 60 hours a week, and it was upheld. But then that, in my mind, sort of drew a contrast with West Coast Hotel, which was the other case you mentioned. But that one was decided differently because of the New Deal, I think you mentioned at the time. And that sort of brought to mind the question of politics and law, how they interact, because in that scenario, you seemingly have a rule of law that sort of bends a little bit with the political landscape of the time. And so my question is, to what extent are law and politics sort of separate disciplines, and to what extent are they continually binded?
Well, I mean, politics influences law and law influences politics. There are certain things that politicians want to do, but they can't do because the court will say you cannot do that. So in other words, this is a system what the Americans have as checks and balances. It operates slightly differently in the United Kingdom because here you have sovereignty of Parliament. Parliament can do whatever it likes. No court can stop it, right? Is basically the general proposition. There are limits to that doctrine in the United Kingdom as well, but the United States is fundamentally different. The three branches, the Americans have a mistrust towards legislation and politician. That's why you have a constitution. That's why you have a Supreme Court, right? So the fundamental starting point of the US is different. Is actually the belief that if you have power, you will abuse it. Doesn't really matter what your intentions are and how good your intentions are, you will abuse it and somebody's got to provide a check on that. The question is, how much of a check are you providing? That's basically the question where justices need to be clear. They're not lawmakers. They don't have a democratic mandate. They have not been elected. The people have not said, yes, we are going to put you into this position, certainly not on the Supreme Court. So you need to trade a very basically fine balance, and Chief Justice Roberts is actually a very good example of that, because as Chief Justice, you need to have your ear on the ground of what happens in the political realm, and you need to say, to what extent do we need to consider this when we make our decisions? The danger, of course, for that will be that legal decisions will be influenced by what do the politicians want to hear. Which actually it shouldn't be. So that's why you have extensive reasoning in these cases where you say, here is the methodology. That's why the methodology is not just something that lawyers sort of say, yeah, great, lawyers do that. No, it is the essence of what you do, because you will be judged and held accountable on the basis of the methodology that you use. That's why whether you ground this in dignity or autonomy, or you ground it in deeply rooted in nation's traditions, these things do matter, because this is what you will be judged against, right? So this is where lawyers and justices pretend they're operating on a different level. To be honest, they don't, right? There are some of those who actually say, there's a realism school amongst sort of legal scholars will say, it depends what kind of breakfast you had. That's the kind of decision you're going to make in the afternoon. If your breakfast was good, you basically will be more generous. If your breakfast was bad, you will be less generous. And there are those who actually say, realistically, judges are always listening what goes on in the political realm. They just dress it up when they come to the reasoning. So they're just the reasoning to the decision that they want to make. And there is some truth in that, but most lawyers that you will speak to, or justices on the Supreme Court, will utterly reject that. But there is basically some kind of suspicion, there is this interplay. The most celebrated justices of the US Supreme Court were always those in the dissent. Right? So take, for example, Justice Harlan in Plessy to say, what you're doing is fundamentally wrong. There is no such thing as separate but equal. Forget about that. It just does not exist. It is just a fantasy. Or basically the justices in Bowers who said, well, how wrong can it be until you realize you cannot simply arrest somebody for having sex with somebody else or for using contraceptives. So it's these kind of principled decisions that people make. But you can say, is that a legal decision or is that a moral decision that they have taken? It's just morally wrong, therefore it must be legally wrong. Therefore, it will sometime down the road be politically correct to say this, but not now, right? So the zeitgeist, if you want to have a word for that, like the Germans use, what is the trend of the time, will not affect the best lawyers out there, but it does affect most of them because they're not the best.
Interesting. You mentioned that judges don't make law, and they shouldn't, on the basis that it's undemocratic. But if they're referencing in their judgments this sort of constitutional bedrock, the Constitution, and that was made by sort of very white-centric, male-centric, tiny group of people, in 1848. In what sense is that democratic either?
Well, that's a question of, that's a mark for wider question of legitimacy of sort of constitutional amendments. Remember, the Constitution that was made by the end of the 20th century allowed slavery. You can say there's nothing more wrong with a constitution than a constitution that allows slavery. if you basically think about it, most people at the end of the 18th century would have said, well, slavery is okay. Go to Roman times, the Romans has no problem with slavery whatsoever. It was the background of the economy that they were running. So times change, therefore. So the question is, how legitimate is a decision? The problem, of course, is if you start like, oh, the Constitution is illegitimate because, then, of course, you can forget all of this. None of this, what the Supreme Court decides, will have any legitimacy if you question the very basis on which it is made. I think what we sort of need to bear in mind is actually a bit of humble realism of human nature and the limitations of human beings, that we are not all, we don't have all the wisdom, things change, we'll need to be mindful of that. And if it was a bunch of white guys, mainly men, or all of them men in 1868, and make a decision, a methodology that relies on that is not unproblematic. Let me just phrase it that way. So in other words, you need to realize, is this the best way we can interpret the Constitution, right? If you are not saying the constitutional text is wrong just because it was made by somebody we might disagree with in their composition, and I don't think anybody disagrees with the text of the 14th Amendment, but the methodology by which we interpret it must take account of that fact. We need to be conscious of the limitations. Yes, you're absolutely right. The problem is now that while Justice Alito may have been right to say you have taken this too far with dignity and autonomy in one direction, now basically moving it back to rational basis abandons judicial review in its entirety. So the problem is Casey sort of was trying to do a middle ground. What I didn't say was Casey said, yes, the state can intervene, but the state cannot place an undue burden on the woman. So in other words, the right to abortion need to be respected, but the rights of the state equally need to be respected, and you need to find a balance between the two. Now, Dobbs has moved that in the other direction, has said we're applying rational basis. So if a state says there shall not be an abortion at all whatsoever, that will be assessed against rational basis because there's no right to an abortion. Therefore, the woman has a liberty interest. If the state says the right of the unborn outweighs any of your interests, that will be fine. And this can even be an ex post explanation. In other words, rational basis means the legislature doesn't have to give any reasons whatsoever. They can just say, we outlaw all abortions. And then some lawyers afterwards can make up why. The Supreme Court accepts that. That's what rational basis means, right? So, in other words, one can say rational basis really isn't a check by the judiciary on the legislator. It doesn't require reasoning to be given at the time, and it doesn't even require the reasoning to be more than just a thin veneer for whatever the legislator really wants to do. In other words, there is no check. Look at the number of cases that the Supreme Court has overheld of not having a rational basis, and probably my 10 fingers will be all you get, right? So, in a sense, you're right, it has now moved in a direction where one wonders, is there any check? And the answer probably would be no, there isn't. At least not for abortion. And soon maybe not for privacy entirely either.
Yeah.
Sorry. Are there other countries in the world which also have such an ambiguous or open interpretation to liberty? And as a result of that, could dogs be relied upon, or could they seek interpretation from dogs, resulting in this issue spreading more widely?
This is a very good point, because you will have noticed the French just recently came together in a composition of constitutional amending Congress. In other words, the Assemblée Nationale, the lower house, and the Senate came together to amend the French constitution to enshrine the right to an abortion. Interestingly, the Conseil Constitutionnel, the French Constitutional Council, which is the equivalent of the Constitutional Court in France, had already said there is a constitutional right to an abortion. So people said, well, do we really need a constitutional amendment? And those who introduced the constitutional amendment went back and said, yes, but look at the United States. These things get overturned, and then what have we got? So that's where they say, here is a window where we want to make sure that we put this out of the reach of the political, the legislator, and the judiciary. So we take this away from the legislator and the judiciary and will enshrine it in the constitution by an overwhelming supermajority. So France has exactly gone down the route that you say. They were worried this would happen, and they dealt with it. Interestingly, India, as I said at the beginning, has a provision, I think it's Article 8 of the Indian Constitution, which gives you a right to personal liberty. But one can debate then for the next 5 hours, what does that personal liberty actually mean? It says everybody has a right to personal liberty. Well, what does that mean? The German Constitution has a right to personal liberty and sort of strike a balance between the interests of the state and the interests of the mother. Equally, India has tried to strike that balance and has now said there is a right to an abortion for unmarried women. And so most states around the world try to strike that balance, right? Because it is a right that is sort of not just one-dimensional. It does just not affect one or two. It basically affects a wider range. There is the unborn, there is the mother, there is the state. And most constitutional courts strike a balance. DOPS seemingly does not strike any balance whatsoever. It doesn't even attempt to strike a balance. And that is basically what makes DOPS and the US Supreme Court a bit of an outlier in this. A similar provision I think you will find in the Canadian Constitution that harks back to due process, but they deliberately wanted to introduce this, and I think, if I'm not entirely wrong, have interpreted away from the American model. So this is basically unclear, but sort of clear in its understanding for the Canadians of what it means, and it shouldn't mean what the Americans have done with it, but basically, in a sense, like sort of similar, but in its obscurity as to what rights are actually protected, I would have thought. But most constitutions around the world do strike that balance and don't veer in one or other direction. So France currently is an outlier in one direction, the US is an outlier in the other direction.
Yeah, thanks.
Given how frequently, increasingly frequently, the Supreme Court overrules decisions on abortion cases, how permanent can we think that the Dobbs case will be on abortion laws? Can we expect that this change will happen again?
Yes, that is when my students ask, do I really need to read that dissent? So that's why you need to read the dissent, because that dissent that you don't want to read now to save time will be the majority decision in 30, 40 years. The answer is yes. We don't know when, we don't know basically how, but at some point it might well be that DOPS will be around for the next 100, 200, 300 years. I don't know, or it will be overruled. But given the tradition of the Supreme Court to actually every now and then take stock and say, okay, was that the right decision? Do we need to overrule it? Much will depend on the composition of the Supreme Court, right? So therefore, Biden v. Trump is not just about the political direction of the United States. It will also basically decide what happens next if there is a next Supreme Court appointment. Because remember, Donald Trump made 3 appointments, and all 3 were conservative justices, and that tipped the balance in the other way. Now imagine where that balance tips back. Then basically you will have sort of a direction of travel where now the dissent will be again the majority. And you see that in the history of the United States. For example, Allgaier and Lochner, the dissent said the Supreme Court shall not make economic decisions. That dissent then basically in West Coast Hotel became the majority and actually provided a ruling. So the answer is yes, swings and roundabouts, as everything in life.
Yeah.
Biden has intimated that. Actually, I don't think he was serious about it, but yeah, okay, one never knows how serious when you float these things. At the moment the White House floats something, it is actually serious, because otherwise they wouldn't have floated it. But there are basically consideration of Democrats who said if Biden is the next president, the composition of the Supreme Court will have to shift. Now, every president, and even Roosevelt, who had an overwhelmingly Democratic mandate. I think he was elected with one of the greatest majorities a president was ever elected, and basically ruled Congress with the Democratic Party. Even Roosevelt floated the idea but never carried it out. It was just waiting for the Supreme Court to actually say, okay, are you getting the message? And they got it, right? The question is, if Biden wins the presidential election, will the Supreme Court continue? The answer is yes. My prediction will be they will not be stopped by this. They will just continue. So if you want to pack the court is on you. It's a political decision that you have taken and you will be responsible. But until that time, we are going to roll back.
Yeah.
Is there any debate about reforming the way that justices are appointed rather than having political appointees?
That is always a debate in the United States of how these justices are appointed, because you go in front of the Senate, and the Senate's job is to probe, but actually quite a lot of those were actually done by recess appointments, where actually the Senate was already the outgoing Senate. You could see that basically when Mitch McConnell was basically the leader of the Republicans, who actually had just lost the Senate. And he continued with the hearings until such point as a justice was appointed. You could say there is no legitimate democratic mandate, therefore that raises a question mark. So if the president of one party and the majority in the Senate of another sort of align, the question is, what's the job of the political process? Quite a lot of countries around the world appoint their justices much differently. They will appoint them by an independent commission, for example. There might well be a composition of both parties then, but it's not just that you have the majority. What matters is you need a supermajority for a justice to get through. In other words, this might well be the move towards everybody can agree on the person. It might not be the best lawyer, but it's certainly one that has the confidence of both sides of the political divide. That might be equally problematic. Or you might have a system where the justice community actually recommends a case. That for a very long time was the UK approach, that you simply recommend somebody who will say, on the grapevine, we think X, that's the recommendation you do, and then X got the gig. And so you can think of different places. But I think in the United States, the bipartisan nature of politics at the moment is where the two parties are so far apart, the appointment of basically a justice by just the person in power or the people in power is not a great way to appoint people who actually go above the fray and actually are independent of the political process.
If I can jump in there. You said that the balance of the Dobbs decision was affected by Trump's appointments, right? You said 3 conservative justices. At what point then does the Constitution sort of become rendered meaningless if it can be sort of changed and like the outcome of its reading can be affected by political decisions? Does it not become a purely political vehicle then, and it loses some of its concrete, fundamental legal nature?
That is always the problem of any kind of constitutional court that you have. So one basically complaint about the Supreme Court of the United Kingdom is it basically does not intervene as much as it should. So Lady Hale, for example, has been probably more activist than other basically presidents, but still sort of the Supreme Court of the United Kingdom is not particularly earmarked. The government might see this differently, but it's not particularly characterized by an interventionist approach as much as the Supreme Court of the United States has been, right? Decisions Roe v. Wade were highly politically sensitive. Obergefell was highly politically sensitive, and so is Dobbs, right? So justices in the Supreme Court do not shy away to actually wade directly into a messy political debate. You could actually say, the question would then be, are you convinced by the reasoning? That's where reasoning matters, right? So that's what they are accountable for. And it's not just that they are politically accountable, there is an invisible accountability stream to the lawyers out there in the United States. Do not underestimate that lawyers in the United States or justices on the Supreme Court are linked with universities. They go in and they face students when they give talks, and the students ask questions. So one of the biggest force are academics and students in the United States in town hall settings like that, where they say, what did you mean by 1868 being the benchmark for this? Can you explain, right? So this is a constraint. And when the student then asks in the United States, does that mean you're overruling Obergefell? And that is a discourse that in their head, they have to think through, how does this affect my standing in the legal community, which is important to these justices. They are not there, basically. One shouldn't see Justice Alito and Justice Thomas and all others as sort of mindless people who just follow whatever Trump tells them to do. That's decidedly not the case, right? They're independent thinkers long before Donald Trump basically wanted to be president, and they basically have written articles and books about it, and so has Kavanaugh. So in a sense, like, one should treat them sort of as, with the respect that they deserve as justices. They just have a different understanding of what the Constitution means, and often it might basically align with basically an agenda of a president, but often their standing stands and falls with the recognition they have in the legal community. So that if they start crazy stuff, totally crazy stuff, then they will lose that support. And if they have lost that support, then that's the end of their career. They might still be in office and do things, and it's a lifelong appointment, but I would seriously think that is a legitimate check on them, that people don't often realize how important that check is. That's why it's important that academics write articles in the United States, the students ask questions in town halls and so
on. You mentioned this is about the importance of a constitution. It brings up the UK has no codified constitution, right? And is there a sort of danger of a similar thing happening here, given that we don't have that sort of concrete legal reasoning to go to?
Well, I don't think so, because, I mean, while there is no written constitution, there is a set of constitutional principles that people largely sort of align around. In other words, the UK is a far more consensual system. In other words, when there is pressure on the political system, the pressure is not the law, and it isn't the Supreme Court most of the time, but it is these unwritten principles that actually constrain the political process, but they also constrain the justices. In other words, on the Supreme Court, you cannot simply make it up as you go along. You're bound by these principles, but it will be a consensual decision, and it's not a political cleavage, often in the Supreme Court, as is Labour versus Conservative. That just does exist to a much, much, much lower extent, basically, in the UK, I would have thought. So these constraints work, and they have worked well for centuries. Much probably better constraints that the United States has, that has a written constitution. It just often doesn't agree what it means, right? Whereas the UK doesn't have a written constitution, but it has principles that are sort of more or less well understood, and they understand what they mean. So that's a far better way to proceed than actually having a written constitution where people just can't agree what it says.
Can I ask, as an academic who studied this, if you were appointed justice tomorrow, what sort of side would you fall on? Would you fall on it being rooted in tradition and that being the criteria for liberty, or would you be on the side of dignity and autonomy in your reasoning?
Aha, my students often ask me that, maybe because they want to know what the exam answer looks like. But if I were to be appointed, I would basically go down sort of a different route. There's a theory which basically says, what with the second part, I do not necessarily believe in the historical tradition argument, but I do believe in the other part of the test, which often sort of gets neglected, which is part and fundamental to a system of ordered liberty. In other words, is it system critical that there's a right to abortion? Because that's the question the 14th Amendment really asks. It asks, what is critical to actually our understanding of liberty, without which the political and the legal system just wouldn't function. So you could say jury trials in the United States are part of that. It might not be our understanding of how the world works. In, say, France, Germany, it is critical to the UK most of the time. It isn't critical to the French or critical to the Germans, but it's critical to the United States. So in other words, I would basically get the text back to what is originally intended to, like if it is rooted in the history and tradition, but that's not the only benchmark. The more important benchmark is part of a system of ordered liberty, right? So in other words, you then would have to reflect on, is abortion part of that? And I think here the argument is, well, that this is such a personal decision that it is part of a system of ordered liberty. If women cannot make those decisions as women, then actually the system will not function correctly, right? The question is, to what extent should the state come in and impose morality on women? And that's basically an entirely different debate, which I haven't touched upon, because there's an entirely different strand as to what the right of the state is on morality. And the answer is, it shouldn't play a role. I do not believe a state has a right to impose morality on anybody. It has to be reasons of, do I need to protect, basically, the life of the mother? Do I basically the health of the mother, but the state should not make decisions that are deeply personal to a woman, and it certainly shouldn't do that on the basis of morality, would be my understanding, but that's entirely subjective, because I would consider this as an essential part of ordered liberty. There might be other parts of ordered liberty which I will say, well, we'll have to debate. Whether same-sex marriage is part of that. That's basically a different question. Maybe it is, maybe it isn't, but it would require a much more intensive debate of what is in and what is out, and it would basically be then a question of what's the understanding that we'll consensually arrive at in the Supreme Court, and I wouldn't want to say a cleavage between me being a Republican or a Democrat and not just make a decision on that basis. That would be wrong.
Yeah.
Sorry?
Do you ever see there being a successful or viable alternative to the Supreme Court?
No, because it's set up by the Constitution, so we'll have to toss the Constitution out and actually say, let's start again, right? That might be an interesting project to do, and I entirely agree. Maybe this is the right way forward. But I will think every country that believes, as the United States deeply believes in a mistrust of the political process, because the US Constitution is deliberately set up to have these checks and balances. And sometimes it works and sometimes it doesn't. But there is no alternative to a functioning Supreme Court, a constitutional court that imposes constraints on the political process. The problem currently is, I think, as you pointed out, the constraints currently aren't working sufficiently. They aren't sufficiently strong. Doesn't mean that I need to substitute my opinion for that of the lawmaker, but what I do require the lawmaker is give me the reasons. And if your only reason is in Mississippi, I believe basically that the earth was basically created 3,000 years ago, and that's your morality code, and on that basis you impose the law, that would be not a good enough reason for me on the bench, going back to where I would approach for that.
Thank you so much, Professor Türk. I think, unfortunately, we are out of time now. So if we could give a big round of applause to Professor Türk.
Thank you.
Thank you so much again for this insightful talk. I think you've left us a lot of food for thought. Thank you again to everyone for coming. Our third in the lecture series is on Tuesday the 19th, is a colleague of yours coming to talk about the futures of the seas. It's going to be a fascinating talk about the oceans, and we hope to see lots of you there. Can I have another round of applause for Professor Türk for the insightful talk?
Thank you.